like so many people, I met Richard for the first time in my very first class, in my very first quarter of law school. I know several others here have mentioned this. And most people then go on to tell a story about how Richard wowed them or impressed them or put them on the spot or whatever. I want to tell a story about how one of my classmates flipped the table. What? No. So on that very first day, he calls on. It's in the big class. This is 180, and it's torts. Great class, by the way. It was by far. Richard had just finished writing the theory of strict liability, which I still think is his most brilliant work. And the conversations it generated were tremendous. But anyway, first day of class, he calls, about in the middle of the class, he calls on one of my classmates and asks a question, and she didn't know the answer, and he says, well, it's right there in footnote, 37. And she said, well, I didn't read the footnote. And he says something to the effect of, you didn't read the footnote? What are you doing at the University of Chicago Law School? To which she, without missing a beat, she says, because I didn't get into Harvard or Yale. She went on to be a very big player at Skadden Arps. So Richard picked on Nancy Lieberman. Nancy Lieberman, who was a year younger than everyone else in the class.
And older than everybody put together.
So
I picked the wrong person.
So I think of this panel, despite all
Michael, she's become a very loyal alum. I just want you to know.
And she loved Richard. It's really, this is not. So I think of the panel as primarily on constitutional law, just because it makes it easier for my brain to study only one thing. And I'm thinking about this conference as a whole, and we began with a panel on common law. We end with a panel on constitutional law, and it seems to me that is perfect, because this is Richard's most important, and I think extraordinarily important, contribution to constitutional law. That's where you have to begin. That is, you don't start the question of how do we govern ourselves in Washington with political theory. You start it with people and what kinds of rights and endowments they have, and how we go about dealing with that. And so if you don't know what tort, contract, property, and so forth amount to, we have no fixed point. And then Richard, I think first, I'm not actually quite sure if this was his first really conspicuous venture into constitutional law was his book on takings. And this book got the best advertisement, commercial support any law book has ever gotten in the history of the world. When at whose confirmation?
Justice Thomas.
At Thomas's confirmation hearing, Joe Biden is waving it in the air and saying, "Do you believe this?"
What do you mean economic rights?
It was fabulous. And Richard has then gone through discussions of equality, non-discrimination, any number of other issues, and then just a few years ago, it's so heavy, so long, the classical liberal constitution, which is a tour de force and which, again, one of our, somebody's going to be talking about, I forget which ones are talking about which ones, but this is an extraordinary achievement. Now, I should probably say that Richard and I have very serious disagreements about constitutional law. I'm not even sure we're in the same camp at all. I'll just say what our disagreement is and then sit down. Basically, I'm very concerned about derivation of constitutional principles. That is, where do they come from, on what authority are they based? Whereas Richard is primarily concerned with what are they, what are the principles. So he's really the natural lawyer in the room, and I'm the positivist in the room. And so that has led to many interesting and fruitful conversations over the years. So with that, let me introduce the panel. We have a fantastic panel to discuss these issues. On my far left, your right, William Bode, who is a professor of law here at the University of Chicago. Currently, or for a couple of quarters, visiting with me at the Stanford Law School. Will got a degree an undergraduate degree in mathematics here at the University of Chicago. He did not go to law school. Did you know that? Like a lot of people here. Instead, he got his JD at Yale. Following which, he clerked for a circuit judge who shall remain nameless on the United States Court of Appeals for the 10th Circuit. After that, he then clerked for Chief Justice John Roberts on the Supreme Court and has been teaching for, what, 4 years is it?
I think 5.
4 or 5 years. So he's a newbie, and during that time has written an impressive array of articles, mostly about constitutional theory, and is also the co-editor of what I can unequivocally tell you is the best constitutional law casebook on the market. That's Calabresi, Paulson, McConnell. So Will Bode, and then sitting next to Will Bode is Richard McAdams, who is the Bernie Meltzer Chair of Law here at the University of Chicago. I particularly am happy to be able to say that the alumni raised the funds to have a chair in honor of Bernie Meltzer. Warms my heart. Bernie Meltzer was just not only a wonderful scholar and teacher, but just a fantastic human being. To sit in the Bernie Meltzer chair is just, to my mind, must be an enormous point of pride. Professor McAdams specializes particularly in criminal law and criminal procedure, but also has written some interesting, I guess he's really, a lot of his writing has been in the sort of law and expression, law and literature area. Law as Expression is one of his books, and then I was just looking in the out in the hallway here, a book I want to get, which is called what is it called?
Fatal Fictions.
Fatal Fictions, which is it's a number of authors writing about law and crime. It really looks like a great book, so that'll be fantastic. And then finally, Rachel Barco is professor at NYU Law School and director of NYU's Center on Criminal Administration. She went to Northwestern, went to Harvard Law School, and clerked for Judge Larry Silberman and then for Justice Scalia, and has been just cutting an enormous swath in the fields of criminal, especially criminal law and administrative law and the connections between those two. And are you still a member of the Sentencing Commission?
I am.
And as a member of the Sentencing Commission, which is an extremely important and largely thankless task. I'm glad there's some people with good sense on that commission. So with that, William, will take it away.
So everybody begins with their Richard Epstein origin stories. So here's mine. When I was a fellow on the job market, I ended up writing a very strange paper that I still believe in, arguing that the federal power of eminent domain was unconstitutional, that despite the takings clause, and despite what you may think, the federal government did not have the power to take land in eminent domain, except in the District of Columbia and the territories. And I had breakfast with Richard Epstein, talked to him about this paper, and described to him the thesis, and thought, of all the people who would be able to help me, mentor me through this paper, he was the one. And he told me I was crazy. he said, that can't be right. Haven't you read McCulloch versus Maryland? Read it again. I think you're missing something. I tried to persuade him. It didn't work. I think by the end he said, does Michael McConnell know you're doing this? Somebody needs to talk to you. You're going on the market with this? And I left the discussion terrified, thinking that if I'd lost even Richard, what was going to happen to me on the job market. I will say, Richard eventually agreed to read the paper, and eventually, after reading the paper, sent me a note saying something like, as you know, I thought the contrary position was very persuasive, but you have convinced me. Now, here are a bunch of things you're missing, and things you should have told me that would have convinced me if you told me in the, when we were talking. And so finally, with Richard Epstein back on board the project, I had the courage to go out and try to present this to other people, almost nobody else of whom was ever convinced. Eventually, I got a teaching job here, and the first class I taught was federal courts. And of course, Richard Epstein was teaching in the same room, classroom 1, right before me. And I think it was criminal procedure that year, although, although how can you tell? And Richard would linger. He would stay there. Students would be mobbing him after class. I would get there a little bit early because I was new and nervous. And then he would linger talking to me, and the whole federal courts class would fill up, and Richard would still be there. I think this happened from my very first day. And then he would turn to me and say, so what are you teaching today, Will? And I would say, Ex parte Young. And he'd say, the thing you have to understand about Ex parte Young. And he'd turn and address the class and say, have you all read the Minnesota rape cases? And they would all look a little frightened. And then for 5 minutes, he would hold forth about, what the real meaning of Ex parte Young was and how you couldn't understand it, you didn't understand. And then the next day, it'd be a new topic. So every day, federal courts began with 5 minutes of Richard Epstein teaching federal courts, and then me trying to back clean up. This was actually perfect, especially for the first time trying to teach a course like this. It always gave me something to jump off with when I didn't know the right way with the material. I mean, occasionally I'd wait for him to get out the door and say, okay, just pretend that didn't happen. Sometimes I'd say, yeah, actually he's right. Now let's talk about the Minnesota rape cases for a minute. But having that thrown into the mix, it also gave the students, I think, a little bit more, again, something to look forward to. Since they weren't really sure about me, this untested new professor, but they knew they'd at least get a few minutes of Epstein, and that was worth the price of admission. All right. So all that said, my topic is the use of Roman law in constitutional interpretation. Actually, so at a slightly higher level of generality, there's a question, and Michael alluded to this, about when interpreting the constitutional text, how much should we take account of, and in what way, of background principles that aren't in the text at all, things that would have been known at the time, or things we can assume were floating around in the air, but aren't there. How much of that should we pour in? So how much common law do you need to know to interpret the Constitution? How much does the meaning of a provision get affected by whatever the common law rule was? How much political theory do you need to interpret the Constitution? How much do you need to know what Locke thought about the distribution of assets or redistribution in society to understand the takings clause? How much Roman law do you need to know to interpret the Constitution? Is it all lying back somewhere even further than Locke? And this turns out to be an important question that many people have trouble really proving any particular view about. I think lots of people use some and not others, and aren't really sure how much to use. And it's maybe one of Richard's most distinctive contributions to constitutional law and constitutional interpretation. So in a very recent piece, I'm not even sure it's actually out in print yet, although maybe it is, Our Implied Constitution, Richard expressly takes on a lot of the sort of more text-bound textualists and originalists, who he says, ignore all of the background principles and implied terms that are in the Constitution. They forget that constitutions should be interpreted like contracts, with the shell laid out in the text, but a bunch of implied terms that are not regarded as problematic by parties who respect and enforce them. And goes on to make a series of common law arguments about why the Constitution has to be interpreted with a set of implied norms. It says, anyone who urges these background norms be disregarded is doing serious disservice to the intentions, both express and implied, of all the relevant actors, which in the standard case are often not based on the direct interactions between the parties, but on the background assumptions that both share along with countless others. So you can hear Richard's voice probably better than mine. And this, as you go through the substantive things Richard has written about constitutional law, I think you see over and over again, this is actually part of what drives a lot of his most interesting and important interpretations. I have read in preparing for this all of Richard's constitutional law articles, and I won't even try to cite them all here because I don't have that long. But recently, in writing about freedom of speech, he's argued that common law and constitutional law have to mesh so that the routine enforcement of common law obligations doesn't violate constitutional norms, because they both share at root the same set of philosophical principles. And in a specific piece about the common law for the First Amendment, he argues that a huge amount of First Amendment doctrine that's currently thought of as kind of ad hoc and lacking in any real tether can all actually be derived from common law principles, including the distances of the various buffer zones that the court has allowed for some statutes and not others, and funeral protests versus abortion protests, and you can find it all in the common law if you look hard enough and have Richard to help you. He's proposed, of course, interpreting the Takings Clause in reliance on a huge amount of political philosophy, English sources, Roman law. He's proposed interpreting the Fourth Amendment in light of the principles of the Roman law lex Aquila, which actually, Aquila, thank you, which he says can be used to derive a huge amount of what you need to know in the Fourth Amendment. When I tried to write an article on the Fourth Amendment, in which I was considering arguing that Perry versus Ohio was wrongly decided as a matter of the original understanding. It's probably the maddest Richard's ever gotten at me. And I believe he said, "It can't possibly be wrong. It can't be wrong. You'll find it in Gaius." And then actually threw a book at me. And so I had to sort of grab it back out of the room to try to figure out where Gaius had supported Terry versus Ohio. The case is not in there, but there is, and Roman law, as Richard will tell you, does have the general principle that the more intrusive of a wrong, the more intrusive of a search, the more justification is needed, which gives you the sliding scale that arrests require more cause than stops and frisks, and the next thing you know, you have Terry versus Ohio in Roman law, at least in Richard's hands. And we could do this for all the clauses of the Constitution. So I think this is actually, and even gets a little bit to derivation. I mean, these things get to the question of, when doing this kind of fixed substantive interpretation of the Constitution, is this a legitimate method of interpreting the text, even though the text itself doesn't say anything about Roman law or Locke or a lot of these other things? So I think this is a place, of course, where Richard's contributions are important, mostly more right than what anybody else has said, but maybe also give us a little bit of a sense of some of the dangers of going too far. So to take two obvious examples, constitutional interpretation can't be all background principles. It can't be nothing but political theory with no role for text or original history or structure. At that point, you're not doing constitutional law at all. At that point, it's pure normative political philosophy, which judges and anybody else don't have the authority to impose on top of legislation that we have now. Richard doesn't try to do that. He acknowledges that still the constitutional text is an important ingredient. You've got to be interpreting a clause, the contract model comes in, the key terms are there, and we're just using background principles to flesh them out and to fill in the gaps. Even there, I think Richard finds a lot more law in the gaps, a lot more principles in the gaps than most of us can find. And that's led, I think, to some of the most interesting but also controversial parts of this, I can't lift it, book. Do you believe this? So the many reviewers of the book who have applauded a huge amount of things in there, but one one repeated concern a lot of both originalists and non-originalists have is that the book relies too much on political theory and too little on the ordinary materials for construing the original meaning. That over and over again they worry that it's more classical liberal than Constitution because so many of the principles can't be derived from the text in a straightforward way. I'm not sure that's entirely right. I think when we can talk about it, I think a lot of what Richard concludes is in the Constitution in terms of its basic structure. It may be there if you look hard enough, but I do think it illustrates the worry that if political philosophy and unwritten principles come to the fore, it's harder to convince people that you're doing constitutional law or law at all. Now, at the same time, I think many originalists make a sort of the opposite mistake and think that everything can be found in the text, and if you can't find a principle in the text, it has no role in a court. And this leads them, for example, to be unable to even explain how judges can obey precedent. Because they look at Article 3 and the Supremacy Clause and say, well, the Constitution is the supreme law of the land, statutes, but there's nothing in there about judicial opinions. So therefore, some people argue, precedent itself is unconstitutional. Judges can only apply the kind of unmediated text of the Constitution. That would be a surprise, to any of the founders, all of whom thought precedent was an inevitable part of the system, because it was a background principle of common law and judicial practice that had been something they were familiar with the whole time. So of course that's got to be there. We can worry about precedents getting too strong and eventually papering over the true meaning of the Constitution, but there has to be some role for them. Otherwise, even originalism would be doing something that the framers themselves wouldn't have done. So I think there has to be some role for these background principles. We have to be careful not to use them too much. So what can we do? How can we make it work? My inclination, and much of what Richard writes is consistent with this, is to say that these background principles should come in only if they really had the status of law, common law, unwritten law at the time of the founding. So it makes sense to use legal rules as a background principle in interpreting the Constitution. Precedent established as a rule of law in courts. Sovereign immunity would be another example, a long-standing accepted principle of international law that applies in controversies between the states. That's part of how it can be part of constitutional law, even though Article 3 and the 11th Amendment make no mention of it. So I think some of these principles can have a role. But it makes me nervous when we start repairing at a much higher level of abstraction the things that don't have that same legal authority, to say, political theory that hasn't fully made its way down to the common law, and even, dare I say it, a lot of Roman law. So Richard's arguments are the most powerful and the most effective when he's relying on the fullness of the common law. I think the First Amendment articles that Richard's written recently are a great example of this. The demonstration that all these common law principles can actually be mapped onto and generate First Amendment doctrinal rules that tell you when constitutional suits for libel, intentional infliction of emotional distress, and buffer zones, and all these things being regulated is brilliant and probably right. In the Fourth Amendment context, where Richard's interpretations often rely at that high level of abstraction principle that tells us that Terry versus Ohio is commanded by principles of Roman law, I worry that there's a little too much theory and not quite enough law, making it all the way down. And then I think it's always best to close with something concrete that of course Richard has written about already. So the Supreme Court has a pending case, South Dakota versus Wayfair, which is whether or not to overrule a previous case called Quill, which says that states can't tax internet sales by retailers who aren't physically present in the state. And if you read the briefs, they're all about this unwritten clause of the Constitution, the Dormant Commerce Clause, with sort of confusion about, first of all, where does the Constitution regulate dormant commerce in the Dormant Commerce Clause, and then how do we apply that here? Is the right conception whether this is discrimination, or one of the parties is arguing that the court should just engage in the Pike balancing test, balancing the burdensome. And as I looked through and tried to figure out, well, what would Richard Epstein say? And I looked at what he had said, but what would he say? I found out there's a common law rule about this, of course. The Union Refrigerator Doctrine. Union Refrigerator Transit Company versus Commonwealth of Kentucky from 1905, and many, many other cases from this era, in which the courts repeatedly held that it's essential to the validity of a tax that the property be within the territorial jurisdiction of the taxing power. Why? Because of a fundamental political theory principle incorporated into the common law that the state taxes you in exchange for the protection it provides you, and the protection the state provides you is within the state's borders. So the state can tax the people who are present in the state because the state is protecting them all the time with its laws. People not there aren't getting the benefits of the state's protection and therefore don't have to pay for the protection they're not receiving. That principle actually may well be an intelligent way to interpret, say, the takings clause, which allows taxation that's not considered a taking, but presumably only if it sticks within the classical and constitutional definition of what counts as a tax. So maybe this helps us explain why we should keep the rule, why states shouldn't be allowed to tax out-of-state commerce, because to do so would really be to engage in taking of property not present within the state, thereby violating the common law principles as incorporated into the takings clause, providing a firmer and more historical foundation than all this sort of dormant commerce clause balancing, and maybe a reminder that Richard's use of common law and background principles can actually solve real cases better than the law. Thank you.
Oh, I might, either one.
Okay,
Okay.
Yeah, I was gonna refer to myself being the last speaker, okay.
I've just disappeared, yes.
As the
Okay.
next to last speaker.
As the penultimate speaker. Now, so the range of Richard's scholarship is so staggering that, as a member of the last panel, I can imagine that we could have several more non-overlapping panels, and we haven't touched yet on the topic of my essay, which is the fact that in the 1990s, Richard wrote what is still the most trenchant criticism of employment discrimination law in a series of articles and the book Forbidden Grounds. Richard had the intellectual independence to challenge the orthodoxy and advocate against Title VII and other laws that prohibit private employment discrimination. Now, as it happened, I entered the Legal Academy only 2 years before Richard published his book, and I did not agree with Richard's position, and it turned out that, and this is my origin story, 2 of my first 3 publications as a law professor involved exchanges with Richard. And one of those came at a San Diego symposium on his book, where I got to meet Richard for the first time. And I particularly remember the conference because it involved, as I think more conferences should, an excursion to the zoo. We went to the great San Diego Zoo. And I think it was there that I figured out that Richard had opinions on a lot of things. Because I remember standing before the giraffes and hearing things about giraffes. So, in any event, my start to teaching was humble, and so to echo Kathy Sharkey, I would have never believed then that I would now be participating in this event, and I'm very honored to be here. My exchanges with Richard were a good introduction to scholarly values in that I had to think seriously for the first time about the normative justification for highly orthodox and generally unchallenged laws against private discrimination. And I continued to disagree with Richard, but I learned immeasurably from his work. And in thinking about this conference, I was led to wonder if we had any points of agreement, and I've decided we do, and I'm going to focus on 2. One is the first is a basic normative framework. So among academics, and I think maybe among people in general, the way that people think about discrimination law is about rights, and it attracts a lot of deontological theorizing. There are a number of philosophical theories for why discrimination is morally wrong. I think one might incorrectly read Richard as offering a contrary deontological approach based on libertarian rights to property and contract as the basis for rejecting discrimination laws. He does carry forward in the book this idea that begins earlier in his work about the proper role of government in the market is to protect people from force and fraud, and then he makes the argument that discrimination, which is a mere refusal to deal, is neither force nor fraud. That might sound like a non-consequentialist argument, but I think that the more careful reading of the book is that it's relentlessly focused on the cost of anti-discrimination law. He spends a lot of time talking about type 1 and type 2 errors, as he did in other contexts that have been mentioned here, and the problems of public choice driving discrimination law beyond whatever its initial purpose is, and argues the benefits are small, either because unhealthy discrimination is being diminished by market competition, and because a person usually only needs one job. So I think if there was any uncertainty in reading the book, one of the San Diego commentators kind of raised this, and Richard's response was that these simple rules he was advocating were really grounded in what made for better consequences for social welfare. So this is an unorthodox way of thinking about discrimination law, but I agree, while I disagree with the conclusion, I agree with the framework. And in the paper, I've decided, I make a couple of arguments for why I think consequences are important in this area to think about, rather than some deontological approach. Now, I could then, what you might think I would do is take some deontological arguments about discrimination and critique them, but I have a couple of more general points. One is just the obvious familiar point that law does not track entirely morality, and there are many places in the law where it's perfectly legal to do something that is immoral. So we've talked from the first panel about promise keeping, and only a few of the promises people make are legally enforceable, even though it may be immoral to break a larger number of promises. Lying is sometimes fraud, but frequently lying is perfectly legal, even if it's immoral. And the failure to rescue people who could easily be saved is often lawful, even though it's discussed as being a place where the law does not track morality. So even if you have a deontological theory that says there's a concept called discrimination and it's morally wrong to do it, we'd still be left with the question of whether it's the kind of moral wrong that the law should prohibit, and that might, one would think, turn on whether discrimination was not only wrongful but also harmful, that is, on its consequences. A second reason I encourage people to look at consequences is because there's a lot of peculiar gaps and asymmetries in discrimination law that have recently generated a number of scholarly articles, including on my colleagues Saul Levmore and Lee Fennell. Discrimination law often doesn't apply to firms below a certain size, having a certain number of employees, doesn't apply to partnerships or how partners treat their partners. The law doesn't prohibit employees from discriminating against employers, and for the most part, it doesn't prohibit buyers from discriminating against sellers. And these omissions strike people often as a great puzzle. They are certainly puzzling if one is looking for a moral theory to explain these kinds of structures. It seems not to fit with common intuitions to say that it's perfectly okay for for an employee to pick, what firm they work for based on the race of the owner or manager, or to pick what fast food restaurant you want to patronize for the same reason. But it's not so puzzling if one is looking at a balance of cost and benefits. There may be reasons that certain kind of discrimination is more harmful than others, and certain kinds of regulations are more costly than others, and a firm of a certain size might have economies of scale that allow them to absorb the discrimination regulations at a lot lower cost than individuals or very small firms. So I think of Richard's work as a compendium of the cost of using governmental coercion to prohibit private employment discrimination. And part of what I do in my paper is to try to catalog, to offer a list of potential benefits to discrimination laws. Now, because any cost-benefit analysis requires an exhaustive list of both. Now, I think Richard will no doubt think my list of benefits consists of the theoretically dubious and the empirically dubious, or maybe some that are both. And we could argue about that, but I'm not even going to spend my time sort of defending these. I'm just going to point out a second area of agreement, which is I can use these benefits to justify one of Richard's substantive criticisms, not of Title VII, but his rejection of the Age Discrimination in Employment Act. My argument is that this act, not only looks bad if you look at the costs, but it also doesn't look very good if you look at the benefits. As I count them, there are plausibly 7 consequential benefits for banning discrimination, and yet almost none of these apply to age discrimination. So here I'm influenced by the economics literature, and so I try to catalog arguments that appear in various places. And so how much time do I have? I think I'm going to skip. So some of these theories depend on, some of these normative theories depend on what the underlying positive theory is of what discrimination is. And I'll just say the first two, without really getting into what they are, I'll just say the first two benefits come out of a theory of discrimination that it's the product of discriminatory preferences, like Gary Becker's theory. And neither of these seem applicable to age discrimination in that